I want to call James Dole next. Nope.
Thank you very much, Mr. Chairman. My name is James Dole, for the record. I am the Advocacy Director at the Campaign for the Fair Sentencing of Youth in Washington, D.C., and I'm here to provide testimony in support of Senate Bill 796 and House Bill 6926. I thought that there's a couple of different ways to view this issue. There's sort of the moral lens, and then there's the legal lens, and I thought I might focus a little bit on the legal lens and address some of the questions that some of the committee members asked previously regarding the trilogy of cases that have come down from the U.S. Supreme Court, and then close with some of the moral aspects of why these particular types of policies are so important for the state of Connecticut, and provide some national landscape as well to this particular issue. I think it's important that when we're talking about the Supreme Court cases that they be read as a trilogy. Justice Kennedy, who's the author of both the Roper v. Simmons and the Graham v. Florida opinion, highlights three important aspects in the Roper decision that carry on to the Graham and to the Miller decision as well. First is the underlying brain and juvenile behavioral development science that was emerging at the time that wasn't available at the time that a lot of these sentences were imposed upon young people. And what that brain science shows us is that the prefrontal cortex, the part of the brain that's responsible for decision-making, essentially the CEO function, isn't fully developed in young people. And essentially they rely on the amygdala, a more primitive part of their brain, to actually make decisions. This makes them more susceptible to peer pressure, makes them more impetuous, and for anybody that has a child or a teenager who's acted out, certainly people can relate to that. And so that part of the juvenile brain and behavioral development science was central to the court's holding. It also informed the courts this notion that kids are unique because they have a unique capacity to grow and change and develop over time. And takes away from the penological justifications for imposing the harshest possible punishments. And this was, again, in the Roper decision, which struck down the death penalty for juveniles. The second thing that Justice Kennedy highlights is the international consensus against imposing the death penalty on juveniles. Specifically, was cited in the Graham decision is the Convention on the Rights of the Child, Article 37. President Ronald Reagan's administration played a very active role in the development of several of these provisions. Unfortunately, even though we have signed on as a party signatory, we have failed to ratify it. We're one of only two nation states, the United States and South Sudan, who've not ratified that convention. And one of the big reasons for that is Article 37 that prohibits the death penalty and life without parole sentences. So there's this international consensus that Justice Kennedy also pointed to that says, look, the death penalty is abhorrent, it's a human rights violation for children everywhere else in the world except here in the United States. So that was the second big component of the case that was highlighted. And the third thing, and this became a recurring theme in Graham v. Florida and Miller v. Alabama, which is that there's this great difficulty distinguishing between youth whose behavior is a result of developmental deficiencies associated with youth and the rare juvenile offender whose actions may represent irretrievable depravity. And so based on that, the court goes on and abolishes the death penalty. In Graham v. Florida, they outlaw life without parole sentences for juveniles, kind of along those same lines of reasoning, how difficult it is to distinguish between those kids who can be rehabilitated and those that can't. And then it also goes a step further and likens life without parole to the death penalty, because in effect, the juvenile will never have an opportunity to leave prison alive. They will leave in a box. And so Justice Kennedy was very clear about the fact that imposing life without parole on a juvenile is akin to the death penalty. And then Miller v. Alabama, of course, not only struck down mandatory life without parole, and I think this is an important distinction and may help highlight, I think, where the Connecticut Supreme Court is coming from. Not only did it strike down mandatory life without parole and invalidated statutes in 28 states, but it also required, Justice Kagan's opinion required that the sentencer consider the mitigating factors of youth any time a child faces a potential life without parole sentence. And this is important because we can look to state Supreme Courts and how they've interpreted this opinion. I'll highlight South Carolina, which is a pretty conservative state. Recently, they came out in a 3-2 decision, finding that the Miller decision applies to South Carolina, even though it has discretionary life without parole, because of the fact that the individuals faced a life without parole sentence and the mitigating factors of the youth were not considered. We can also look to neighbor Ohio, State v. Long. It's another state that has looked at these discretionary issues and held that, in fact, the Miller, Graham, and Roper progeny of cases applies to these discretionary sentences. And so I think that helps to explain a little bit about how some of the courts are interpreting the language. I think it is important that they be read together, and specifically the language about how difficult it is to distinguish between juveniles who commit serious offenses who can be rehabilitated and those that cannot be. So in light of these decisions, several states have abolished life without parole wholesale. Some of the states I'll highlight are Texas, Kansas, Kentucky, Wyoming, Montana, Hawaii, Massachusetts, and West Virginia. I mention those states because they represent pretty broad geographic and political diversity. We're seeing bipartisan support on these issues really across the country. West Virginia has probably enacted what we would term probably the most significant legislative reform in terms of how juveniles are held accountable when they commit serious crimes there. West Virginia, the legislature abolished life without parole for children and also required that they become eligible for parole eligibility no later than after they've served 15 years. And so certainly when we look at the parameters of SB 796, House Bill 6926, those are definitely in line with how other states have responded and what we view to be in line with the meaning, the letter, and the spirit of the Roper, Graham, and Miller decisions. And finally, I'll close. I know my time is up here. I'll close out just by saying, and I'll quote Newt Gingrich, who we've worked with, former Speaker Newt Gingrich, who we've worked with on legislation in California, who supports these types of policies as well. He says, he quotes Scripture, and he says, Jesus tells us to do unto others as we would have done unto us. And how would we want our kids treated if these happen to be our children who got caught up in the system? We'd want to give them second chances. And so really these policies are about mercy. They're about potential for second chances and the potential for redemption of our young people. And certainly if children aren't deserving of our mercy, then who amongst us is? And so with that, I'd close and be happy to answer any questions that you have.
Are there questions for Mr. Dole? Seeing none, thank you very much for your information here.